new state Supreme Court ruling could put hundreds of home foreclosures in question.
It has to do with just who has the legal right to foreclose on your house. Consumer problem solver Connie Thompson is staying on top of this. She's here with what it means to homeowners whose mortgages are tracked by a company known as MERS.
Thank you, Dan. MERS, M-E-R-S, stands for Mortgage Electronic Registration System. It's a central tracking system that essentially represents the person or investor that holds the note on a loan when a mortgage is sold. The problem? Lenders have been using MERS to initiate foreclosures, even though MERS does not hold the loans. And in this decision, state justices say that is not what our state legislature intended.
Jekyll, come on.
When Kristen Bain hired an attorney to fight illegal lending practices with her condo, she never dreamed the case would end up in Olympia.
You couldn't imagine the things that were running through my mind.
Bain lost her job, missed mortgage payments, and was sent to foreclosure by MERS, a tracking system. Lenders claim MERS can act as beneficiary instead of the actual loan holder. But attorney Melissa Heelsman cried foul. Citing state law, she filed lawsuits, stopped the foreclosure, and last March went before the state Supreme Court to argue her case against MERS, the lenders, and their attorney, Robert Pratt.
The lenders specifically chose to make MERS that beneficiary.
But the plain language of the statute makes it clear that they are not, in fact, a beneficiary, as defined by the Washington legislature.
In a unanimous decision, the 9 justices just ruled that under our state law, the beneficiary who initiates foreclosure must hold the promissory note. What's the bottom line?
Obviously, the court said, no, MERS cannot be that entity because it is not the note holder and it never is the note holder, right?
Heelsman says the implications are huge, with the potential to affect hundreds, perhaps thousands of foreclosures initiated by MERS in this state in the past 10 years.
I'm certainly happy with the victory, but there's a lot more work to be done.
Kristen Bain must now return to court to determine who owns her loan, how much she owes, and whether she is owed money because of how her mortgage was handled. This ruling could open the door for legal action by other homeowners who've been foreclosed by MERS instead of an actual loan holder whose name is on that promissory note. But the justices in this ruling also say that having MERS on your loan doesn't mean you have a case. The question is whether you suffered unfair ramifications because of MERS. I have put the full decision on the consumer page of KOMOnews.com. It's a lot to read and understand, but there will be a lot of ramifications.